Welcome everyone to this Privacy Rules Privacy Espresso. As you know, I'm Alessandro Di Mattia. I'm Legal and Executive Officer at Privacy Rules. And today we are going to discuss about one of the most relevant topics of the moment, because we are going to speak about data breaches and in particular data breach notifications under GDPR with a specific focus on Poland. We have with us Karolina Miksa from the firm UKW from Poland, of course, that will give us an overview on how things are going there and what the regulator is saying in relation to this topic. So without further delay, Karolina, thank you for being with us, and I turn it over to you.
Hi everyone. Hi Alessandro. First of all, let me thank you for inviting me to join this week's edition of Privacy Espresso. It's a pleasure to be here. And thank you for your kind introduction. As Alessandro already mentioned, I want to discuss a little bit about data breach notifications, as it is one of the major obligations of the GDPR. Data breach, obviously, as you all well know, can be a major incident, such as the unauthorized access to a database of more than 2 million customers, which happened in one of the biggest cases in Poland. However, data breaches are also less significant incidents. And the very common one that happens to our clients is sending email with a copy of a contract or documents containing personal data to a wrong person. It's a typical human mistake to misspell an email address. Recent decision of the Polish Data Protection Authority, which I would like to discuss today, also concerned misdirected emails. So generally, a data controller is obliged to assess the possible risks of data breach, and if a breach may lead to physical, material, or non-material damage. In case the controller identifies risk to data subjects, rights or freedoms, which he or she associate with the incident, it is obligatory to notify the DPA about it. In addition, when the potential risk is particularly high, the controller should also inform the data subjects, each person individually or, when it's not possible, by public announcement. So the facts in the case were that the insurance agent addressed email to a client using email provided by that client. However, it turned out that the email address is incorrect. The agent attached to the email an insurance policy with personal data of the client. Contact details, address, and PESEL, which is Polish National Identification Number. I will refer to it as PESEL. That data concerned two people, the client and her husband, as they were co-owners of the car insured by the agent. The insurance company found out about the incident and decided that due to the absence of risk posing to data subjects, rights and freedoms, it won't notify the regulator about it. The company decided that as information was revealed only to one person, and plus considering that the nature of the data, incident will not have any adverse effect on data subjects. The DPA didn't agree with that approach. The proceeding was initiated by the unintended recipient of the email who informed DPA. Regulator decided to impose an administrative fine on the company for lack of notification. The DPA not only found that the incident had posed a risk, but identified it as a high potential risk. In the DPA's opinion, espresso has been revealed along with other personal data. The possible implications could have been severe. We are having difficulties in explaining this approach to our clients. The Polish DPA took a peculiar position that for the mere reason that PESEL has been revealed, the breach automatically is identified as posing not only a risk, but also a high risk to data subjects. And historically, there might have been a case when, with a name and a PESEL number, it was possible to use someone's identity, for example, in shadow banking system. Nevertheless, currently, with better regulatory activities of authorities regarding security, It is not possible to get, for example, a loan by providing only personal data and a PESEL number. For that reason, the DPA's position on the breach seemed to us to be unjustified. The fine in the case was insignificant. It was only around 20,000 euro. However, considering the facts of the case, it still seemed unfounded. The DPA has never before published any guidelines or other good practices statements on how to assess a data breach and risks to data subject associated with it. We would expect the regulator to rather provide some clear guidelines to the companies and then decide to impose fines in case the company is not following such guidelines. And particularly, DPA has never explained why, in its opinion, revealing PESEL number to only one person is posing such high risk on data subjects. PESEL is not a sensitive data. And in Poland, at least, it's a broadly used identifier. For example, in identifying board members in public registries. And for some years now, it is obligatory to provide PESEL in any lawsuit against a natural person. So it is required by companies in Poland to provide PESEL by customers when entering into a contract to be safe when there is any lawsuit against that person planned. The case is not closed yet as the company filed an appeal to the court. However, with this case and only two others issued by the DPA and concerning data breach notifications, the picture for the data controllers in Poland is not any clearer. The DPA did not provide any broad risk assessments in any of these cases. To sum up, good breach assessment is crucial in the process of maintaining compliance. However, it poses many difficulties, especially with no recommendations from the DPA and unclear reasoning provided in just a few cases. As we can see, with almost 3 years after GDPR took effect in Europe, it is still unclear for most businesses how to manage personal data incidents. In my experience, I only saw several organizations with good data breach action plans and even fewer with an effective implementation of such plans.
Thank you very much. That was really interesting, Karolina, and that was a really great point. I mean, this is not the first case I heard about, DPAs that were not providing some guidelines on specific topics and then possibly, issuing fines for something that was really difficult to understand for companies.
Yes, and we would at least expect good reasoning in this decision. And when you read it, there is nothing clear about it. They just give you this one statement, two statements, no assessment. So yeah, that's the other problem, that you cannot fully understand the reasoning of the regulator.
Okay, and that's also make a bit difficult, I can imagine, from a lawyer perspective to prepare a defense, because you have no real idea on why they are issuing a fine for.
That's true, yeah, and it's risky for us, right? Because the companies are expecting us to give a good recommendation, and we cannot. We just have to say we don't know what they're going to do.
Karolina, we ran out of our time, so thank you very much for being with us.
Thank you very much for having me.
It's been a pleasure speaking with you, and I really want to thank all our listeners in the recording and live, and I really look forward to see you very, very soon again. Bye everyone, and bye Karolina, thanks again.
Thank you, bye-bye.